You are charged with driving while your license is suspended. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
It's Judge. On February 3rd, 2025 at 11:40 a.m., the officer ran a license plate search on a vehicle and found the vehicle to have expired registration. A traffic stop was then initiated. The officer notified the defendant for the reason of the stop and asked for the defendant's driver's license. The defendant provided a Texas ID that did not belong to him, and the officer asked for a name and date of birth. A search of the information provided showed the defendant's driver's license to be ineligible, and the vehicle also did not have valid insurance. And the officer did a person search on the defendant and found the defendant had a bond condition for an ignition interlock device, and that the vehicle did not have the interlock. The vehicle is registered to the defendant.
Let's go through your stuff. And I'm just from 2009. DWI, possession of a controlled substance, robbery, theft, possession of a controlled substance, felony theft, felony theft. Here's my concern. 2018, DWI second. 2019, DWI second. 2019, possession of a controlled substance. Further in the year, DWI second. Possession of a controlled substance, and now another DWI. And now driving on a...
This judge isn't just frustrated. She's afraid of seeing another tragedy unfold. You can hear it in her tone. When someone racks up multiple DWIs, the law's patience runs out. It stops being about punishment and becomes about protection. This warning feels like her last olive branch before the hammer comes down. What do you think? Should repeat offenders even get bond at all?
Suspended. I don't know if you watch the news. Every single day, someone dies from an alcohol-related collision in our county. Every single day. Watch the news. It's really, really unfortunate when a button on a phone and $30 on an Uber will get you to anywhere you want to go in this damn county. Don't matter where you want to go. It's a geographical oddity. It's so easy to just hit one button. I don't know what we need to get through to you, Mr. Benjamin, but I don't know if you're going to bond out. You will be signing an affidavit with me today, promising me you're not going to drive. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. Every single time you get behind the wheel, you can be facing 6 months in jail and up to 6 months in jail and or a $500 fine. Do you understand? Do not drive. It's really scary what happens every single day in our county, and it's so tragic. Don't drive. This is the promise that you're going to make to me. All I'm begging you to do is don't kill someone. Please, don't kill someone. You're being held at no bond on your DWI third upstairs as it is. And I don't know. Right now, they gave you a PR bond in this case, and I don't know if that's appropriate because you scare me. You just, according to this, I find by clear and convincing evidence that you just refuse to comply with bond conditions. So I don't know if I'm going to give him a PR bond. You know, he's driving a car here. He's supposed to have an interlock. He doesn't have one. And so I don't know. So for now, I'm going to have you sign the affidavit. It is a part of your bond condition. Don't be a danger to my county. Otherwise, I will make your bond very, very high. Do you understand? Get a clue, Mr. Benjamin. It's not hard. Come on. You're Lauren Thompson. Ms. Thompson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
One moment, Your Honor. It's Thompson, correct?
Oh, sorry.
Okay. Okay. On February 8th, 2025, the officers were traveling on 4300 Luella Avenue in Deer Park and observed a motor vehicle driving with an expired license plate. The officer confirmed with TCIC and CIC and performed a traffic stop. Upon making contact with the defendant, he observed bloodshot eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant admitted to consuming 3 alcoholic seltzers, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a sample, and a blood search warrant was signed and executed.
All right, Ms. Thompson, I'm going to find that there's probable cause to go forward with your case. Any prior to DWIs, and does she have a license?
No priors, Your Honor, and I'm running her license right now.
She doesn't have any priors.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. As long as you're not using, everything will be fine. If I find that you're consuming alcohol, illegal drugs, I'm going to revoke your bond, put you in jail. Do you understand?
Your Honor, we'd like to state that she did tell the officer that she had taken some medication. So she did explain to the officer that she was under some medication. So we would like our concern is the revocation of her license. There's motions for.
I'm not revoking her license. I mean, you may continue to drive, just if it does become suspended at a later point, you just have to be cognizant of that it does, that you're not allowed to drive. So just be careful. You know, I don't know what's going to happen with the ALR hearing and all that. So just be careful. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her, and she'll tell you if and when you have to come back to court. Just don't consume alcohol. Don't use illegal drugs. If you're taking or no unprescribed.
Notice the shift here. From anger to caution, the judge moves from scolding to mentoring, almost as if she's trying to stop another headline before it's written. That's what makes moments like this so powerful. It's not just a law at work. It's humanity trying to break a cycle. If you were the one on the bench, would you show the same mercy?
Controlled medication. If you're taking medication prescribed by a doctor, that's absolutely fine.
You tell us, Your Honor.
Okay, just understand that if you're taking a controlled substance,
Yes.
even prescribed by a doctor, if you take too much, it can be an intoxicant. And if you get in a car, it's bad news. So you just be very, very careful. You understand? Okay.
Thank you, Your Honor.
I'm going to have you sign a resale. Victoria will have you sign your bond condition for Felicia, and then you guys are free to go. Thanks. That way. Good morning, ma'am.
Good morning.
I don't know if the TVs are working, but your lawyer's here with you on Zoom, so you know you're not alone.
Tell me.
Okay. Ms. McElveen, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, man.
Yes, Judge.
Okay.
On February 28th, 2025, the officer observed a vehicle run a red light on Derry Ashford and Westheimer at a high rate of speed. And upon catching up with the vehicle, the officer observed the vehicle run another red light at Kirkwood and Westheimer, both intersections in Harris County, Texas. The vehicle was estimated to be traveling at 80 miles per hour, and a traffic stop was conducted. The officer observed glossy eyes, slurred speech, and the defendant was unaware she had run the lights. The officer asked the defendant to exit the vehicle and observed a strong odor of an alcoholic beverage and an empty container of an alcoholic beverage and a half-empty open container of wine.
For drinking while driving?
There were open containers,
Stop.
Your Honor. And standard field sobriety tests were conducted. HGN 4 out of 4, walk and turn 7 out of 8, one leg stand 3 out of 4. And DIC was read. The defendant consented to breath. The results were 0.146 and 0.144.
And I'm going to find that there's probable cause to go forward with your case. Are you telling me that she's consuming alcohol while she's driving, Alex?
Let me read the full judgment, Your Honor, and see if there's any.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you consume alcohol or illegal drugs, then I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
Your Honor, they were just partially full. There's no indication they were cold to the touch or anything like that.
There is no observation of her drinking while driving.
And then I'll run her license, Your Honor.
Anytime you have an open container in a car, it's a minimum of 5 days in jail, flat to any sentence that you get. I would hope that it's elementary that you don't have alcohol in the car while you're driving.
Oh, Your Honor.
All right. You have a lawyer. Because you have a lawyer, I will waive your appearance. However, you must stay in touch with Mr. Dietrich, and he'll tell you when you have to come back to court. No alcohol, no illegal drugs. If you do not have a Texas driver license and liability insurance, you're not allowed to drive. So if you don't have liability insurance in your name, do not drive. It is a condition of your bond. Do you understand? All right, I'll have you sign a reset with Victoria. We'll have you meet with Felicia for your bond conditions, then you're free to go. Mr. Herrera, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 6th, 2025, the officer was notified by a witness that a former student, the defendant, was inside Spring High School. The defendant was unenrolled from the school by the associate principal on February 4th, 2025, and was told not to return. Spring ISD school records show the defendant is no longer an active student, and the school officer and associate principal advised the defendant to leave on February 6th a second time, not to return. The officer observed the defendant walking on the walkway with other students, and the defendant continued to walk in the officer's direction. The officer observed the defendant pull his hoodie over his head while walking towards the bus ramp area. The officer was in full uniform and gave the defendant a verbal command to stop and follow the officer to his patrol vehicle. The defendant disregarded these verbal commands and began walking in the opposite direction. The officer grabbed the defendant by his left arm, and the defendant began to resist, pulling away to the point where he started coming out of his hoodie. The officer verbally commanded the defendant to stop, and the defendant broke loose and used evasive foot maneuvers to gain distance from the officer in the direction of an open parking lot. The officer notified Spring ISD police and requested assistance. The defendant was detained 300 yards from the initial interaction.
So he was where?
He was at Spring High School.
I know, but was he in the outside or was he?
He was on the outside walking towards a parking lot and walking with a group of students when the officer interacted with him.
He was outside. Was he, so any
Still
point?
on the property, Your Honor, of Spring High School, and they told him not to return to that high school. They told him on the 4th of February not to return to the high school, and he was
Yeah,
on the property.
I understand that,
Mhm.
but he's on the outskirts, he's on the sidewalk.
He was walking on a walkway with other students.
Walkway of the school,
It was
near the parking lot of the school, which is owned by the school.
Yes, Judge, it was the walkway with other students, and that's when the officer saw him and tried to make contact with him.
I mean, I'd like to know where, you know, is he on public property? Is he just on a sidewalk on the outside of the school, you know? Just walking?
He was with other students on the walkway walking towards the
Is
bus.
that,
Further in the DMs, it describes it as the walkway near the portable buildings located north of the band parking lot. So,
let's do this, Mr. Herrera. I'm gonna appoint you a lawyer today so we can get down and dirty with your case a little bit more. Just take a seat for me in the jury box. Let me get you a lawyer, okay? Ma'am, you were charged with assault and bodily injury. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
yes, Judge. On February 9th, 2025, the officer made contact with the complainant, who advised that she and her husband and friends were outside by their motor vehicle, hanging out, and the defendant was saying things to them about them being illegal. The complainant and the defendant started getting into a verbal argument, and the defendant started to attack the complainant while the defendant was holding her baby and was reaching around the baby trying to fight. The complainant advised she sustained injuries during the assault and was in pain and was in fear for her life. The officer observed the complainant to have scratches and whelps on her right arm.
Hate crime? Ms. Riverbark, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with these people and not to be in possession of any weapons. If I find that you're a danger to my public, and I don't care who it is, I will revoke your bond, put you in jail, and I'm going to make your bond sky high. Do you understand? Do we know if alcohol played any kind of part in this?
There's no allegations of alcohol, Your Honor.
And filing those conditions, no contact, no going within 1,000 feet of where this person lives or
Yes, sir.
works, and then no weapons, please.
Yes, Judge.
Ms. Riverbark, you have the ability to hire a lawyer. Okay, we're going to reset your case to give you time to hire a lawyer. I will have you sign a reset with Victoria. After that, I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man. Good morning, Ms. Singleton.
Good morning.
Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was dispatched to an apartment complex on Dominion Park Drive and met with the complainant, who advised that the defendant is her roommate. The complainant stated that the two had a verbal argument over rent, which led to the complainant gathering the defendant's personal belongings and throwing them outside of the residence and onto the ground. Approximately 100 feet from the front door, The defendant then walked towards the complainant and struck her on the face and torso with a closed fist, causing the complainant to lose balance and fall to the ground. The defendant continued to strike the complainant until the defendant's boyfriend pulled her away. The complainant advised she felt pain.
Singleton, I'm going to find that there's probably cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. It looks like a protective order was issued on the 8th of this month. I would get to know it because if you do something to violate the protective order, like go to the house that's listed in this thing, even if they give you permission, the state can and will file a violation of protective order. It's one of the worst cases you can pick up. Do you understand? You're also not to be in possession of weapons as well, ma'am. No contact, no weapons. Ma'am, do you have the ability to hire a lawyer? Okay.
I can.
I'm sorry?
I can.
You don't want to apply for a court-appointed lawyer?
Thought I had one.
No. You have one during magistration just for that very purpose, but that it ends at that stage. It doesn't carry with you forever. So at this moment, you don't have a lawyer. Do you want one?
May I have a court appointed?
Okay. I have an application on file there for the Marine. Don't worry.
Oh.
I have an application already on file. I will have you sign a Risa Victoria. Don't be a danger to my community because I only have one place for you if you are. Do you understand?
Sure.
You won't get another warning. Haltavian Edwards. Mr. Edwards, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:04 p.m., the officer observed a vehicle with an expired registration as of December 2023. A traffic stop was initiated and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer smelled a strong odor of marijuana and observed the grip of a green handgun underneath the front center folding third seat directly within the defendant's wingspan. The officer asked the defendant how much marijuana was in the vehicle, and the defendant stated 7 grams. A PC search was conducted and the officer retrieved the handgun, which was loaded and unholstered. The officer also located a marijuana cigarette and 2 clear plastic bags containing a green leafy substance recognized as marijuana in the center console with a weight of 3 grams.
All right, Mr. Edwards, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
Does he have a valid Texas driver license?
It appears that his license is expired, Your Honor.
You don't have a license. You're not allowed to drive. I don't care what's going on in your life. You want to drive, go get a license, get liability insurance, and then I can take this restriction off. But if I find that you drive, it's really not going to go well for you. Do you understand?
Yes, sir.
You will be signing a promise with me. This is an affidavit that you're not going to drive. And I hope that you heed this warning because I take it absolutely seriously. I don't care what's going on in your life. I don't care if it's a burning building. You have to go save 50 kids. Don't drive. Shoot.
There was another firearm in my vehicle. It was a rifle. Do I have the right to?
You need a lawyer. I can't give you legal advice. The only thing I'm telling you is I don't want you in possession of any weapons. So don't, because I'm going to put you in jail if I find that you violate these conditions. No more PR bonds. Do you understand? A lawyer can answer all these questions for you. I'm just not allowed to give you legal advice. Do you have the ability to hire a lawyer, sir? So what I'll have you do is I'll have you fill out an application. Let me take a look at it to see whether you qualify. And if you do, then I'll give you a lawyer. But above all else, do not drive. All right, I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria, sign a reset. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions as well. Mr. Saines, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated. I'm sorry, not to be probated, with 67 days in jail to give you credit for it. And it looks like you also have a terroristic threat. It looks like they're going to dismiss this case as a result of this plea bargain. Is that how you understand it? You give up a lot of rights by entering this agreement. You give up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, give up the right to appeal. Is this what you want to do?
So,
How do you plead to the offense? Guilty or not guilty?
yes, I guess
I'm sorry?
Guilty to the criminal trespass that we talked about. You're pleading guilty to the criminal trespass. Do you understand? And they're dismissing the terrorist statement, so they're not guilty. So you're not guilty. So you understand? That's the same similar trespass. You have to tell the judge that.
Thank you, sir.
Are you guilty of the criminal trespass?
Sir,
Okay. You know what we're doing, right? That it's going to go on your record. From now on, you're facing a minimum of 30 days in jail, all right? If you go back to, where was it, Alex?
Your Honor.
Time-wise.
The trespass was at a McDonald's, Your Honor.
If you go back to this McDonald's, you will end up going back to jail. So you can't go back to this McDonald's, all right? Okay, sir. Good luck. Thanks. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The wheel witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard fields of riot tests were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. It's what the road they said it happened on.
Where is it?
It said US 50, that's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious?
It says-
Do I need to look it up? I don't know.
Your Honor, the
I did.
DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway.
I
So they
just heard
put,
50.
so they put 50, but then later in the DIMS, they did put 59.
All right.
So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or it's at 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas, 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put
I'm not working on hunches here, man.
and I understand, Your Honor. The officer initially said he responded to a crash call.
This last exchange says it all. From tense hearings to a judge sharing candy with a teenager, it's a reminder that behind all the legal talk lies a genuine effort to steer people away from disaster. Courtrooms aren't just places of punishment. They're where second chances are offered, tested, and sometimes redeemed. The real question is, if one were offered to you, would you take it?
Service which occurred on US 50, but then later said the accident occurred on 59. So let me see if
Can't
we
definitively
I
point
guess
where it is.
I'll check the OR and see if they clarify in the complete OR. And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas, 77004.
So is 50 It's not in Harris County?
That's
He
50,
switches
Highway
between
50.
50 and 59 in the offense report sheet.
I know. I won't call.
Yes, Judge, and we understand.
All right, Joe.
Thank you, Judge.
All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to, he's great. He'll help you out whenever you need, you know? All right, man. Good luck.
Excuse, Judge.
For that law 5.
How are you? Have you been to the Van Gogh Museum?
No, sir.
It's great. It's awesome. Man, it's really cool. You should go one day. How are you?
I'm good.
How old are you?
I'm 15.
He's awesome. He's so great.
He was looking
You
forward
got to
meeting-
follow
He
him.
was looking forward to meeting you, Judge.
Here, how about some candy? We have some cookies over there too, if you want some cookies. Oh, can I give him candy?
It's all good. He's 15. He can bring his own.
Well, I don't. You got to follow in his footsteps. You know, that's what it's all about. Knowledge is power. When you know things, you go so far in life and you get money. That's what counts, right? Yeah.
Appreciate it, Judge.
If you ever want to come hang out and watch what we do, stop by. We can have you sit in the chair over there and just kind of hang out and just watch what we do. Yeah,
Sounds great. Thank you.
absolutely.
We had a day off, so I figured we.
I know my kids are off too.
Yeah, yes, sir.
We're gonna go to the movies now. I'm just gonna go see the Marvel movie.
Everybody have a great weekend.
Yeah, you too.
Thank you, Judge.
Okay, bye, Mr. Brooker. So are we done?
Yes, Judge, we're done.
All right.